Fair use doctrine can be understood with the analyzing or reviewing a couple of judgments. I have with me a couple of judgments pronounced both in India as well as in the global courts, which will give you an idea of what is fair use doctrine. The first case is very popular case. When you talk about fair use doctrine, you can't escape from this particular case. Actually, this was in 1799. The USA's first president called George Washington, he died in 1799. He left his voluminous correspondence to his nephew called Bushard Washington. He was also a Supreme Court judge, and he gave it to him to take care of the publication of the volumes of letters, correspondence or writings and many things. So, the first president gave all his voluminous work to his nephew. The rights to these documents were subsequently acquired by Harvard University historian called Jed Sparks. So, from 1834 to 1838, Sparks, he took about 4 or 5 years to publish the entire writings of president and a 12-volume work of nearly 7,000 pages, a majority of which were Washington's letters. He wrote many letters. So, of the 7,000 volumes, 7,000 page volume, it is nothing but more than letters. So, this series was printed in Cambridge by Harvard's former librarian and official printer called Charles Folsom. So, a printer called Folsom, he publishes it in the Massachusetts. So, in 1840, Boston publisher Bela Marsh, he announced a new 2-volume life of Washington by Reverend Charles Wentworth Upham. So, although life of Washington created original scholarship by Upham, it also included hundreds of Washington's private letters copied directly and their entirety from Sparks. So, Folsom brought suit against Marsh and Upham for piracy of the copyright in Washington's private letters. So, the argument is copying of Washington letters from the earlier published work by the later work. This is the argument. Folsom versus Marsh. This was heard in 1841, almost 42 years after the death of George Washington. The Supreme Court judge called Joseph Story, he is the very important person in the discussion of fair use policies. So, Joseph Story, he is listening to the entire discussion, he is the circuit court judge for the district of Massachusetts. And Justice Story held that this fact specific inquiry depended on the nature and aspects of the selections made, the quantity and the value of the materials used, and degrees in which the use may prejudice the sale of the original work. Probably you could connect this with the 4-step procedure that is being established by the court. The very same judge, the Justice Story, is the one who is behind the entire creation of the 4-step formula that is being followed by the US courts even today. So, taking these factors into account, Justice Story reluctantly affirmed the lower court and ruled that attendance copying of so many private letters in their entirety was not a fair and bona fide abridgment, but a copyright piracy. He categorically that this is not a fair and bona fide abridgment. You have not converted the 7,000 pages volume into two volume story, but you have done whatever you have done is nothing but a copyrighted piracy. That was the upheld by Justice Story. So, Justice Story given presaged transformative use, we have seen about the transformative use of the copyright document, right. He was the one who thought about the transformative use of the document, and noting that fair abridgment, even if it is an abridgment, a fair deal of abridgment was more likely when the defendant creates an original and new work from the copied materials. Even if it is a copied material, and if you have interpreted and classified, arranged into new form, then that will be called transformative material, and Justice Story gave a new life to the understanding of the fair use policies. So, after the pronouncement of Justice Story's judgment, over 150 years of time has passed, and after the pronouncement of Justice Story's pronouncement of this judgment, another judge called Souter, he credits the Justice Story's arguments, and he said that the formulation of what has become the fair use defense that has been codified in the US Copyright Act in the section called 107. Section 107 of US Copyright Act is very popular in dealing with the particular fair use policies, and the father of introducing this is none other than Justice Story. It all started with the Washington's writings, and that was case number 1. If you come down to India, there are plenty of cases in the last 50-70 years we have come across. We will see 1 or 2 cases to make us understanding about how Indian courts have been looking at what is fair deal and what is fair use policies. In one of the earlier case, Wiley Eastern Limited and others versus Indian Institute of Management, the court traced the purpose of the defense of fair dealing to the Indian Constitution. Actually, in this case, the court went to the Indian Constitution to find out if there are any clauses or any sections that can help us to understand how the fair use policies could be looked at, or how the copyright issues can be looked at in a socially democratic country called India. So, they found that the basic purpose of section 52 of the Indian Copyright Act is to protect the freedom of expression. The idea is to protect the freedom of expression that stated in article 19(1)(a) of Indian Constitution, and that promote research, private study, criticism or review or reporting of current events that could be protected. So, section 52 is not intended by Parliament to negatively prescribe what infringement is. And if you look at another case, this is called Rupendra Kashyap versus Jivan Publishing House, where the defendant was involved in the publishing question papers of CBSE examination. Actually, he is a publisher who collects various question papers and he publishes, and the plaintiff contended to hold an exclusive license. He wanted to have an exclusive license of selling or supplying CBSE question papers. The argument comes whether he has the exclusive right or that can be copied or transferred to other agencies. The court has very explicitly held in this particular case that the law as to copyright in India is governed by a statute which does not provide for defense in the name of public interest. So, Indian copyright cannot be compromised in the name of public interest, and infringement of copyright cannot be permitted merely because it is claimed to be in public interest in infringe in a copyright. So, that was case number 2. So, we were very clear that whether it is public interest or the private interest, we cannot compromise on the Copyright Act. That was the decision of the earlier thing. And that final case is called Delhi University photocopy case. It is a very popular case and normally being cited in all the fair use policies as well as in the copyright case. This case is about very large publishers called Oxford University Press and Cambridge University Press and Taylor and Francis Group. These 3 major groups in 2012 they filed a case in Delhi challenging a photocopying company, or it is a small photocopying shop in Delhi University, and that has been challenged whether they have the legal right to photocopy the copyrighted material in the form of books published by these many publishers. And the global publishing giants had claimed that the photocopy kiosk violated their copyright and was causing huge financial losses as students had copied and they stopped buying their textbooks. So, the argument is that the students are going and copying all the books and they do not buy their books. So, it severely infringes their economic interest. Rameshwari photocopy shop, that is the shop that is in Delhi University, and the entire lawsuit by Oxford University, Taylor and Francis, all these big giant companies were against this particular small photocopy shop called Rameshwari photocopy service. And the argument is infringing the copyrights of the plaintiffs in their publications by photocopying, reproduction and distribution of copies of plaintiff's publication on a large scale and circulating the same. So, they are copying the copyrighted material which severely infringes upon the economic interest of the publishers. So, the publishers sought a ban, they want a complete ban of the photocopy, so that the entire India we can stop the copying of copyrighted material. That was the plan of the publishers. So, they sought a ban on all course packages in an aggressive interpretation of the Indian Copyright Act 1957. That was the plan. The section 52(1)(a) of Copyright Act 1957 of India that allows the fair use exemption on any fair dealing with a copyrighted work, be it literary, dramatic, musical or artistic, for the purpose of research and private study. So, for the purpose of research and private study, anybody can make use of the copyright material under the article section 52(1)(a) of the Indian Copyright Act. But section 1 subsection 1 allows the reproduction of any copyrighted work during the course of educational instruction also. So, if it is an educational instruction, that can also be produced under this particular thing. We will see the judgment of this particular case. I will read out a section portions, section segment of the judgment, which will give you a fair idea about what is the case has trying to. It is a landmark case which has stopped the international publishers from encroaching upon the infringement policies of or the fair use policy of the Indian education system. So, I would read out major sections of the judgment which will give you a fair idea about this particular case. Justice Rajiv Sahayanla, he is the judge who reviewed the case. He declared that copyright is intended to increase and not to impede the harvest of knowledge. It is intended to motivate the creative activity of authors and inventors in order to benefit the public. The action of making a master photocopy of relevant portions of the books of these publishers does not constitute infringement of copyright under the Copyright Act. The facility of photocopying were not to be available. They would, instead of sitting in the comforts of their respective homes and reading from the photocopies, would be spending long hours in the library and making notes thereof. When modern technology is available for comfort, it would be unfair to say that the students should not avail thereof and continue to study as in ancient era. No law can be interpreted so as to result in any regression of evolvement of the human being for better. The court in its 94-page judgment also said that nearly all students of the university carry cell phones and most of them have inbuilt cameras which enables them to click photographs of each page of the book and take printouts after connecting the phone to a printer. The same would again qualify as fair use and which cannot be stopped, it said. It cannot be lost sight of that we are a country with a bulging population and where the pressure on all public resources and facilities is far beyond that in any other country or jurisdiction. While it may be possible for a student in a class of say 10 or 20 students to have the book issued from the library for a month and to laboriously take notes therefrom, the same is unworkable where the number of students run into hundreds if not thousands, the court said. According to me, which means according to the judge, what is permissible for a small number of students cannot be viewed differently merely because the number of students is larger. Merely because instead of say 10 or 20 copies being made by students individually or by the librarian employed by the university, 100 or 1000 copies are being made, the same would not convert what was not an infringement into an infringement, the judge said. We have discussed about a couple of cases from India as well as from US to find out what the cases that contributed to understand the idea of fair use policies. And we started with the George Washington letters published by an American company which was later abridged and whether that was the abridgment was accepted. Then we moved on to Indian cases, particularly the significant case called Delhi University photocopy case. These cases have given us an idea about what is infringement and what is copyright and what is particularly fair use policy in the Indian context refers to education system. In this presentation, we discussed about what is fair use doctrine talks about. We started with understanding what the policy is about and how this has been built through various judgments pronounced by UK courts, USA courts and Indian courts. We also discussed about the policies being promulgated through the judgments pronounced by popular Indian cases to build the idea of what is fair use policy in the Indian soil. I hope this would have given you to understand the larger picture about copyright policies and particularly about fair use policies used in the Indian system. Hope you enjoy the lecture. Thank you very much.